Regulation Review Subcommittee will come to order. Please call the roll.
Senator Rocky Adams. Senator Wilson. Senator Yates. Representative Bridges. Representative Frazier Gordon. Representative Marzian. Co-Chair Lewis.
Here.
And Chairman West.
Here. We have a quorum. We are duly constituted to conduct business. First matter of business before the committee is approval of the minutes. Is there additions or corrections to the minutes? Seeing none, is there a motion for approval of the minutes?
Motion.
We have a motion. We have a second. Without objection, so ordered. Before we get into anything at this time, I would like to welcome two new members to the committee. One is a face that we've seen before, Representative Marzian. I think Representative Frazier Gordon said that you would be taking on the responsibility of making the motions again. Okay, we welcome back. We really appreciate that. And then we also have Senator Wilson. Welcome to Administrative Regs. You're no senator there, but we welcome anyway. Do we have any introductions or comments from members of the committee? Seeing none, please call the first regulation.
Council on Postsecondary Education, 13 KAR 002-120 and 002-130. Both of these regulations have agency and staff suggested amendments.
13-120 and 130 amend the funding models for public universities and KCTCS in accordance with 2024 Senate Bill 191, including to revise definitions, remove the underrepresented minority degree production allocation and student credential metric, which are replaced with provisions for first-generation students, add provisions for adult learners, and adjust allocations, weightings, progression metrics, and data averaging. The agency amendments amend various sections and incorporated material to revise funding model metrics in accordance with the Performance Funding Working Group recommendation. The staff suggested amendments amend various sections to comply with KRS Chapter 13A. 13-1-120 is also amended to include the Council's criteria to determine fields of study for a STEM plus H bachelor's degree.
Thank you. Would you please identify yourself for the record?
Yeah, I'm Travis Powell, Senior Vice President and General Counsel for the Council on Postsecondary Education.
Thank you so much. There are staff amendments. Is there a motion for approval of staff amendments? We have a motion and a second. Without objection, so ordered. There are also agency amendments. Are there any questions or discussion on the agency amendments? Seeing none, is there a motion for approval of the agency amendments? Motion and second. Without objection, so ordered. So we have before us the regulation as amended by staff amendments and agency amendments. Mr. Powell, this is not our first rodeo here on post-secondary issues and these particular set of regulations. Mm-hmm. Do me one favor.
Sure. Really
quickly. We do have one gentleman to speak in opposition. Go through it again for us one more time. You can just hit the high notes, the bullet points.
Okay.
of where we were with the formula, where we were at the percentages specifically, and then where we're going with these regulatory changes.
Sure. So just to sort of in sum, these changes were prompted by Senate Bill 191, which was actually prompted by the regular review of the Performance Funding Work Group. It met on its regular 3-year cycle at the end of 2024 and made certain recommendations related to changes to the funding model. So those changes were captured in Senate Bill 191. The only difference in their recommendation and what was actually adopted in Senate Bill 191 was the change of the underrepresented minority student to underrepresented students, and charged the work group with defining what underrepresented students meant for purposes of the model. So just to summarize, in the university model, would you like for me to do both the community college and the university model, or just the university
Let's
model?
do university for now.
Okay.
Yeah.
In the university model, there was an increase in the low income degree premium from 3% to 8%. It added an adult learner metric, which is students aged 25 or over, through additional weight for credit hours earned by those adult learners. It's actually twice the weight, so the credit hours earned by adult learners have twice the weight of those earned by other students. Increased the small school adjustment for Kentucky State University and Morehead State University so they'd have more opportunity to compete in the model. And then increasing the non-resident credit hour weighting from half to 75% of the resident credit hour rating. That also reduced that 5% increase in the low-income degree production from 3% to 8%. There's a reduction of the student credit hour production pool from 35% to 30%. So that's where that additional 5% came from.
Get into the aspect of the economically disadvantaged students, the part that was stripped out and moved, the 1.5% that was stripped out, the under
the 3%.
Yeah. Get into that a little bit, and then get into the weighting.
Okay.
How the weighting changed.
Sure. So the underrepresented minority student pool of funding was 3% in the model. It's actually not in the statute, but the work group tells us to allocate the now 40% to those to the metrics listed in the statute. But through the work group's determination, it was recommended that that these percentages exist. So the 3% was, after the last work group meeting, 3% allocated to underrepresented minority students was the recommendation. So essentially, when Senate Bill 191 passed and told us to remove the underrepresented minority students and change that definition to underrepresented students, it's still 3% of the model. So in the first year, the non-codified language directed the council to take that 3% and allocate 1.5% to low-income students, additional 1.5% to low-income students, and 1.5% to this new underrepresented students metric, which we were directed to define as first-generation college students. So that's essentially defined as a student who has one or has both parents, or one parent that has never been doesn't have a college degree, and the other parent either doesn't have a college degree or they don't know what the college attainment is for that other parent. And so we applied that for the 24-25 distribution. And those funds were allocated per operation of the model in an emergency regulation that was filed that went through this committee. But the statute also charged us with determining the work group to determine how to define underrepresented students moving forward. And so the work group met 3 different times. Several different scenarios were proposed, but ultimately the work group determined to define underrepresented students as it was in the non-codified language as first-generation college students. So then the question became how to weight those metrics. Currently, all the metrics in the student success pool are weighted differently between research universities and comprehensive universities, and that weighting chart is in the regulation materials. So once we defined the metric, then we had to decide how we were going to weight it. The metrics were weighted in the 24-25 distribution. There was a 1-to-1 weighting that was not codified in the language, not directed in the language, but that was the general agreement amongst all the university presidents and the members of the work group that we would not weight the metrics. But there was no direction moving forward. So once the first decision was made on how to define underrepresented students, then we had to determine how to weight those metrics. And so, using the formula that was used to create the other metric, the weighting for the other metrics, gave us a number. Of course, you could weight the metrics 1-to-1. The decision of the work group was to basically take the full weighting between research and comprehensive universities and cut it in half. And so do what we've considered to be a half weighting of what it would normally be based on the way that it's been calculated to weight the degree production half of what it had been done in the past for the other metrics. And so the work group voted on that. It was a split vote. I think the vote was 7-6. For those of you all that don't know, the members of that work group include all university presidents and KCTCS president. It includes a representative designated by House leadership and Senate leadership, and then a representative from the governor's office. All members were in attendance, and again, it was a split vote. And so once the vote came down, we filed these agency amendments to capture what was determined by the work group.
Thank you so much. That's exactly what I was looking for, detailed explanation for members of the committee. Up next, if Mr. Frazier wants to come up at this time and speak in opposition. When you get a chance, state your name for the record, then proceed.
Sure. My name is Michael Frazier. I'm Executive Director of the Kentucky Student Rights Coalition, and I'm also here on behalf of the Eastern Kentucky University Student Government. Co-Chair West, Co-Chair Lewis, and members of the committee, thank you so much. We are here in opposition to 13 KAR 2120, only relating to performance funding for the four-year post-secondary institutions. So we agree that the Council on Post-Secondary Education has the ability under SB 191 to promulgate the administrative regulation concerning performance funding, and in fact that they were charged by it in Section 3, Section 4, and Section 6 of SB 191. The agreement and the legislative intent where we quibble with the Council is the agreement of weights. Now, the question is, what are the weights? And according to a report by the Eastern Progress and CPE's Vice President Bill Payne, the weights are to adjust for the cost of the research institutions for administrative salaries for the research institutions. Now, I bring this up because the mission of SB 191 is also to address how do we serve Kentucky's most underserved students. These are your low income. This is your first generation, as my friend and colleague, Mr. Travis Powell, has stated. But these are also your underrepresented minority students. These are your LGBTQ students. These are your homeless students. And Mr. Powell is correct that 3 meetings were held by the council, because when we're talking about SB 191, we're not just talking about 13 KAR 2.120, the performance funding regulation before us. We're also talking about 13 KAR 2.060 and how we define an issue that's performance funding based upon the statutory intent of SB 191. So in these 3 meetings, which SB 191 was passed in April of this year, months have went by before the council actually held its first meeting with the performance work group. And instead of actually looking at performance funding, and particularly the weights and how to address homelessness on campus, how can we perhaps do the weights to do an unfunded mandate for kids in foster care doing a waiver for higher education? A lot of people don't realize that's actually unfunded. How can we actually solve this and incentivize it? The conversations that ensued are how do we restore the funding to the research universities from the comprehensives? Now, what we're talking about here is $4 million, 3%. That is supposed to be discussed of Kentucky's most vulnerable populations. And while that's a drop in the bucket for multi-billion-dollar institutions like the University of Kentucky and University of Louisville, this matters the most at the comprehensive universities that's disproportionately taking the kids that can't afford UK and U of L. That is trying to be, that these are the rural and urban students of Kentucky trying to go through on scholarship. Now, when it comes to the weights, where we quibble and where Mr. Powell is right, weights, particularly when it comes to performance funding for the relevance of this regulation, is omitted in Section 1 of KRS 164.092 when it comes to the overall 40%. And there is a question if the weights have misappropriately been applied for 40% of performance funding. But for this 3% in that same section, weights are omitted. But SB 191 was not unclear where weights were allowed and where it's omitted. In fact, we're not here opposing the other regulation, 13 KAR 2.130, relating to KCTCS funding, because SB 191 made it clear weights may be applied. In fact, it says shall be applied. So we do oppose and we do recognize the good work and the good intent of the work group here, but where we say that weights are applied, particularly for this section, the reason why we're quibbling with this so hard is that this is the section that actually helps the most underserved students in Kentucky. This is the homeless student that stayed 1.5 years in his car from your district, Senator Wilson, to go to EKU's med program in your district, Representative Fraser Gordon. This is the individual that is trying to ensure that they escape 40% of poverty from Butcher Holler that's going to University of Louisville in your district, Representative Myers in. So while this might be trivial, this is actually life-saving measures and life-defining measures that, one, that members of the committee wasted an opportunity to define, but two, what we believe misappropriately applied within the weights here as part of performance funding. So we do believe that the regulation is deficient by the Council on Postsecondary Education and the work group by applying this weights where the statute failed to mention weights has been applied for this regulation. So our first recommendation is to rule the administrative regulation as deficient. We do think that there is bounds based upon the law and also the legislative intent, because it's not only in the section where the weights are amended, it's actually defined in SB 191, where there's actually specific weights for the Council on Postsecondary Education and performance funding to equalize, to form an equilibrium based upon the distinction of comprehensive and research. So I would argue that the third place where it is submitted or specifically defined is within the last section of SB 195, where it said that the council shall not apply weights. Now the council, and we've had really good meetings on this, I believe, and the council's argument is that the dates are defined in the last section. And I appreciate that argument, but where we would quibble with the CPE is that you can't just look at that section alone. You have to look at the entirety of the section of the statute of SB 191. Weights are clear where it's defined and where it's not defined. And weights are omitted, particularly when it comes to this particular section for the administrative regulation based on today. So that's our first option, is to rule it as deficient. Second, we do recommend for the committee to use its statutory authority to recommend for the General Assembly and this honorable body to define where weights are. And this is something you can do. And I'm aware that some legislators are going to file some bills on this matter to hopefully clarify that. And I think that would also help the council and also the public post-secondary institutions. I would also suggest for this committee to recommend for the Council on Post-Secondary Education to update its cost analysis in compliance with 13 KER .250. And what that is that it has to be an adequate fiscal note attached to it. The council has provided a fiscal note and cost analysis upon this regulation, but where it's deficient in to be an adequate cost analysis is that it does not show how the weighting, which is tiering underneath Chapter 13A, actually costs the comprehensive universities. So that's the third recommendation that we have if deficiency cannot be ruled today. And thank you for your time. And on behalf of poor kids everywhere, we do hope that you'll consider these recommendations.
Thank you so much for that testimony. I'll flip it back to Mr. Powell. Would you care to respond or choose to respond?
Sure. Part of the issue with weighting, just to go back and give a little bit of history, weights in this have been in this regulation since its inception. This was something that was determined by the work group in 2017 and have always been applied between the research and comprehensive university sectors. This was the understanding of the work group and of the General Assembly, if we want to talk about legislative intent at the time, that weights would be included. And this is something that's been made public ever since the model has been in place. It's really becoming an issue in this cycle, but this is something that has been part of the model since its inception. The statute it may not mention weights, but that's part of the regulation process, is for the agencies to fill in the gaps. And again, this is something that had been determined by the work group and been made public for many years at this point. So in defining these terms in the regulation and allocating these percentages, I think CP is well within its authority to apply weighting as in its definition. And this is done in the weighting chart. It's all been made public. And so publicly viewed, and we've never received any comments on this regulation, actually, believe it or not, in any of the iterations that we've gone through with it. So I think we've met all our requirements. I I don't, as far as the fiscal note goes, I've provided you all with some information outside of the fiscal note process. I feel like we were compliant with the regulation provisions in providing the information that we did, but as always, happy to provide more information, provided information to staff about some of the different funding model scenarios and the weightings and the difference that it would make in funding. Again, always happy to answer those questions as fully as I can. All we've attempted to do here is to follow the law and follow the recommendations of the work group and not insert, even though this is CP's regulation, we have never and would never take the opportunity to change anything based on anything CPE wanted to do or may not want to do. We've always been true to the work group's recommendation and any gaps that we feel that have not been defined by legislation. And that's all we're attempting to do today is just to follow the work group's recommendation and move this forward. Mr. Frazier mentions, he's absolutely right, legislation could be passed just as it was in the last session to amend the performance funding model. And if it is, we'll figure out a way to make those changes quickly, just like we did in the last cycle. But if that doesn't happen, moving these regulations forward today and getting them through the end of the process before we have to make our allocations of funding to the state budget office in May will allow these regulations to be in place. So if no changes are made in legislation, then the model can run as determined by the legislation and as determined by the work group.
Thank you so much. Just quick response if you need to.
Sure.
Just really quickly.
And just on that, and I do appreciate that, and not to be persnickety, but the weights are prescribed in statute, and I actually do have the citations, which I sent you all an email to. And the second thing is that Mr. Powell is absolutely correct in saying that the model did not run until May. So if the legislature is in process of consideration, there's no reason why this body has to make a decision today. We can wait until the legislative process because the next model doesn't run until May 2.
Well, just to clarify on that, we actually can't because the way the timing works and when this gets sent to the subject matter committees, it may not have time to get through before the end of the session and before the time for it to run. So we need to move forward on this to get the process moving so we can actually have the regulations final.
Thank you so much. And the reason we're spending so much time on this issue is because it is vitally important to the Commonwealth and to the universities. And so right now we'll open up the floor to questions from members of the committee. For either person, we'll do this a little bit different. This isn't your all's first trip here. We'll kind of mix and match. So whenever you're called upon, if you could just direct your question to whoever you want to answer the question. Representative Frazier Gordon is up first. Senator Yates next.
Okay. Thank you both for being here. And I really don't have a question per se for either one of you, but I do have a comment. And I think the only thing that hasn't been brought forward in this discussion is the impact that it has on our comprehensive. The difference in funding does result in tens of millions less in funding for those universities. And so although I don't think it rises to the level of deficiency today, I do think it's something that we continue to look at, just like we've mentioned, legislatively, and that possibility of removing those weights in the future so that we're actually funding student performance at all the universities. But thank you both for being here.
Thank you.
Senator Yates.
Yeah, first of all, I do appreciate, I know it's a lot of work and time and effort for a lot of people going into it, so thank you for being here. At some point, I believe that we were told that this has been, I know we're just amending the small model, it's 3%, but the entire model, isn't it coming up after so many years, next year, to be able to be revisited?
Yes, so the work group meets every 3 years. It finishes its work in 24. And so in January of 26, essentially, we'll start those meetings so we can have a recommendation by the end of the year.
Okay, for the entire 100%.
For the entire model. And that's what was reviewed last time. And they always, it's actually prescribed in the statute. It talks about a holistic review and performance of the model and making sure it's meeting all the outcomes that we've expected. So, yeah, that happens every 3 years. Okay. So we're a little bit away from that, but starting in 26, we'll get going on that again.
Perfect. Thank you.
Any other questions from members? Seeing none, I don't see any motions on the floor for deficiency at this time. As usual, this will proceed to the Committee of Jurisdiction. So there'll be another bite at the apple at that time, and this will move on down the road. after today. So thank you so much. Appreciate
Can I say one more thing?
Yes.
Yeah, just to say that more than happy to provide any information about not just the 3%, but how the model works in total. Hoping to maybe before the next post-secondary education committee meeting, perhaps in February, we can come and present on the entirety of the model. Representative Fraser Gordon would be happy to sort of just walk you through all the nuts and bolts of how it works, because it can be complicated and it's taken me a long time to get it. I've been working with it for many years, and so I have to go back to it all the time and take a look at it. But would be more than happy to run you through that, especially as you consider legislation potentially filed in the session moving forward about what the impact would be.
Thank you so much. Up next, please call the next regulation.
Teachers Retirement System, 102 KAR 001-195 and 001-340. 340 does have a staff suggested amendment.
102 KAR 1-195 amends provisions to require school districts and education cooperatives to submit to the Teachers Retirement System an annual report of the total accumulated sick leave days for employees participating in the Teachers Retirement System, TRS, a copy of all leave policies, and a copy of all salary schedules for which an employee participating in TRS receives compensation and from which retirement contributions are withheld. 102 KR 1340 amends provisions to establish definitions and refine the method for calculating a TRS member's final average salary pursuant to KRS 161-220-9B. The staff suggested amendment reorders definitions alphabetically and corrects subsequent references in a consistent manner, and makes technical corrections to comply with the formatting and drafting requirements of KRS Chapter 13A.
If you would, please identify yourself for the record.
Yes, good afternoon. Bo Barnes. I serve as Deputy Executive Secretary and General Counsel for the Teachers Retirement System.
Thank you so much. There is a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second. Without objection, so ordered. Any questions from members of the committee on this regulation? Seeing none, please call the next regulation. Thank you.
Thank you.
Kentucky Public Pension Authority, 105 KAR 001-130 and 1-445. Both regulations have staff suggested amendments.
105 KR 1-130 amends provisions to further establish the processes and procedures for an employer to request hazardous position coverage and to convert non-hazardous position coverage to hazardous position coverage, incorporate an additional form by reference, and update existing material incorporated by reference consistent with the proposed regulatory changes. 105 KR 1-445 amends provisions to further establish the procedures and requirements for preparing and casting electronic, telephonic, and paper ballots and the tabulation of ballots for Kentucky Public Pension Authority trustee elections, and incorporate a form used in the trustee application and election process by reference. The staff suggested amendments make technical corrections to comply with the drafting and formatting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
Nathan Goodrich, Staff Attorney Supervisor. It's my first time here.
There you go.
It's Nathan Goodrich, Staff Attorney Supervisor, Kentucky Public Pensions Authority.
Victoria Hale, General Counsel, Division of Non-Advocacy.
Jessica Bobian, Policy Specialist.
Thank you so much. There are staff amendments. Is there a motion for approval of the staff amendments? Just because we said that earlier, anybody can join in on the motions. It's not just those two over there. We have a motion and a second. Without objection, so ordered. Any questions from members on these regulations coming from the Public Pensions Authority? Seeing none, please call the next regulation. Thank you.
Board of Veterinary Examiners, 201 KAR 016520, 016530, and 016590. All these regulations have staff suggested amendments.
201 KR 16520 amends to define approved foreign equivalency program Veterinary Medical Program and Veterinary Technology Program, remove optional alternate pathway to licensure for vet technicians that allowed transcript submission from a non-approved program for board review and determination of approval, allow vet technicians to be eligible for licensure with an approved foreign equivalency program, provide continuity of terms, and remove language conflicting with industry standards. 201 KR 16530 amends to reorganize requirements for veterinarians and vet technicians, shift responsibility for screening from board staff to the national provider, place a cap of 5 times in the number of times a candidate may test, establish procedures for petitioning the board for additional attempts, and update material incorporated by reference. 201 KR 16590 amends to add definitions, define necessity for continuing education, add required hours in CE and pharmacy and controlled substances, antimicrobials, or state or federal laws and regulations related to the practice of veterinary medicine, require a portion of online CE to be in live format, clarify insufficient CE shall be cause for denial, establish perimeters for veterinarian operation in a state of emergency, establish limited hours of CE for board meeting attendance, establish limitations on the number of allowable modules available for CE, establish CE can only be accounted for once, outline requirements for board-approved CE, clarify requirements for proof of CE completion, establish perimeters for board audits during a renewal period, clarify requirements for board waivers, and update material incorporated by reference. The staff amendments for 201 KR 16520, 530, and 590 all make changes to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Michelle Shane, Executive Director for the board.
Dr. John Park, Chair of the board.
Thank you so much. There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion and a second. Without objection is so ordered. I'll start us out with a question here. Does this have anything to do with the Murray State Veterinary proposal?
No.
I'm just joking. I'm just joking. Just joking about that. Any questions from members? Seeing none, please call the next regulation. Thank you.
Thank you.
Thank you.
Board of Nursing, 201 KAR 020057, and this regulation has a staff suggested amendment.
201 KR 20057 amends provisions to clarify that the electronic system used to monitor scheduled controlled substances is maintained online and may be queried for information, and update standards incorporated by reference to the most current versions. The amended after comments version deletes language allowing an exception for an APRN to prescribe hydrocodone combination products for more than a 3-day supply if the prescription is prescribed as part of a narcotic treatment program licensed by the Cabinet for Health and Family Services. The staff suggested amendment amends provisions to delete references to a repealed statute, update the names of material incorporated by reference, and make technical corrections to comply with the drafting and formatting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
Kelly Jenkins, the director at the Kentucky Board of Nursing. I can't speak.
Good afternoon, Jeff Prather, General Counsel, Board of Nursing.
Thank you so much. There is a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second. Without objection, so ordered. I just have one quick question before we start here. The online monitoring system, wasn't that already online and operational? Why are we doing this?
We're updating the reg to come into compliance with the way the system works now, because the APRNs are still required to check CASPR, the PDMP that will be, if it's no longer CASPR and it becomes the prescription monitoring system in Kentucky. But the information's still there, but they have to now just document when they did the check and put that in the file, as opposed to actually running a physical report, which a lot of APRNs practitioners don't do anymore anyway, because it's just the system is well beyond that.
Got it. Thank you. Any questions from members on this regulation? Thank you so much. Please call the next regulation.
Thank you.
Board of Emergency Medical Services, 202 KAR 007401. This regulation has both agency and staff suggested amendments.
202 KR 7401 amends reciprocity provisions to implement House Bill 57 from the 2024 regular session of the General Assembly. This amendment allows certified or licensed paramedics in any state to be eligible for reciprocal Kentucky certification or licensure instead of only allowing reciprocity in states contiguous to Kentucky, deletes provisions relating to resuscitation procedures, determination of death, and preservation of evidence consistent with House Bill 57's repeal of KRS 311A 185, and establishes a sunset provision for paramedic critical care endorsements. Originally on and after January 1st, 2026, paramedics providing critical care would have been required to obtain an advanced practice paramedic license and certification as a critical care paramedic. The agency amendment postpones the sunset date for critical care endorsements from January 1st, 2026 to January 1st, 2027, and establishes the date the board shall stop accepting endorsement applications as June 30th, 2025. The staff suggested amendment makes technical corrections to comply with the drafting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
John Wood, outside counsel for the Board of EMS.
Eddie Sloan, Kentucky Board of EMS.
Thank you so much. There is a staff amendment. Is there a motion for approval of the staff amendment? There's a motion and a second. Without objection, is so ordered. We also have an agency amendment. Are there any questions or discussions from members of the committee on the agency amendment? Seeing none, is there a motion for approval of the agency amendment? We have a motion and a second. Without objection, it is so ordered. So we have before us the underlying reg as amended by staff amendment and agency amendment. Any questions from members of the committee on this set of regulations? Seeing none, please call the next regulation. Thank you.
Thank you all.
Tourism, Arts, and Heritage Cabinet, Department of Fish and Wildlife Resources, 301 KAR 002081, 002082, and 002225. All of these regulations have staff suggested amendments.
3012081 is being amended to allow the possession of native wild rabbits and establish species and permitting requirements for wildlife taken and transferred to foxhound training enclosures. 2082 is being amended to allow the possession of wild rabbits, hares, and pikas within Kentucky, with the exception of European rabbits. And 2225 is being amended to reduce the length of the September teal season and disallow the use of decoys by dove hunters on department-controlled lands during the month of September. The staff amendments to these regulations amends various sections to comply with the drafting requirements of KRS Chapter 13A, delete repetitive language, and make technical changes.
Would you please identify yourself for the record?
Jenny Gilbert, Legislative Liaison.
Stephen Fields, Staff Attorney.
Thank you. There are staff amendments. Is there a motion for approval of staff amendments? We have a motion and a second. Without objection, so ordered. As usual, it would not be a meeting of administrative regs. I have a fish and wildlife set of regulations here. I believe my co-chair has a question that I actually had the same question.
Yeah, so Jenny, I've got a 7-year-old daughter, and for Christmas this year, she asked me for a rabbit. We'll address that in the spring. But my question is, what is the difference between a hare and a rabbit?
The Latin name I cannot give you. Sorry, I would have to bring a biologist here for that. But there are distinguishable features within the way those species interact and the way they look, their ears, several other features that I think that they could distinguish very clearly from looking at it. You and I probably wouldn't be able to. But specific to the reg, there is a type of European rabbit that you cannot tell the difference between the wild and the domesticated. And the wild is what carries disease that we do not want in our native rabbit population. So that is why it is specified here. It's a correction we should have made the last time this reg came through, which you see this one often, unfortunately, because species, we learn new things and disease change. And it was just inadvertently left off. So that's why there is a clarification on the type or the species of rabbit here. So
Okay, thank you.
your local pet store should not carry it, though. If they do, let us know.
Fair enough. One other question, if my co-chair will allow.
Please proceed.
We've been watching in the news lately on cases of bird flu, and of course you're seeing this a lot in California. Is the department, I know that you didn't come here specifically this day, to address that, but is the department tracking this, or have they seen any cases of anything in the wild that may or may not have been affected by bird flu?
We are watching that very carefully. Our department veterinarian actually sends out updates, and there was a disease report specific to CWD, but we also include other wildlife diseases in that we had to file. It's a statutory requirement, and I submitted that at the end of last year, kind of late fall. I'll get you a copy of that. It specifically has some information about what we're doing and how we're watching the avian bird flu as well. And then she sends out a wildlife health newsletter to our staff and our commission. I can get you a copy of that as well, because it is more tailored to what she is seeing and what her crew are watching for and working within the field, and some of our field staff are looking for when they're talking to not just sportsmen, but frankly farmers who are dealing with that a little more closely too.
That'd be great. Thank you.
Any other questions from members? Seeing none, please call the next regulation. Thank you.
May I ask, do you want me to send that to the committee? Do I do that through staff and then they send that
That would be
report
fine.
out? Or okay.
That would be totally fine.
Okay.
Is it okay with you? Yes, it's fine. Please call the next regulation.
Justice and Public Safety Cabinet, Department of Corrections, 501 KAR 006 410. This regulation has both agency and staff suggested amendments.
This administrative regulation establishes department policies on inmate life and issues, including missing or stolen inmate property, personal hygiene items, marriage of inmates, legal services, board of claims, inmate grievance procedures, sexual abuse prevention, and lesbian, gay, bisexual, transgender, and intersex inmates. The staff suggested amendment amends Section 1 in the material incorporated by reference to comply with 13A drafting requirements, update edition dates, and add a field in the policies for the previous effective date. The agency amendment amends Section 1 and CPP 14.8 to remove procedures for hormone-affirming treatment and transgender-specific surgery, and to update the policy edition date.
Would you please identify yourself for the record?
Good afternoon. I'm Leah Boggs, General Counsel to the Public and Justice and Public Safety Cabinet.
Good afternoon. Nathan Goins, Office of Legal Services, Staff Attorney.
Thank you so much. We have before us, this reg has a staff amendment. Is there a motion for approval of staff amendment? We have a motion and a second. Without objection is so ordered. We also have an agency amendment. Are there any questions on the agency amendment? In this particular regulation, before we get into questions on the agency amendment, if you could just please give us bullet point version of what the agency amendment does.
Yes, sir. The department completely withdrew the previously proposed CPP policy 14.8, and we filed that agency amendment on January 8th, and we replaced it with a 2018 version of CPP 14.8, which was effective in 2018 after being approved by this and the other legislative committees. The department is reviewing the Attorney General's opinion and will be working on an amended policy that we'll bring back before you all that will comply with the requirements of the Federal Prison Rape Elimination Act, and recognizing, as the Attorney General's opinion also does, that certain medical care other than gender-affirming surgery may be legally required when a health care provider determines it to be medically necessary for serious medical needs. And as you all know, the Prison Rape Elimination Act is a federal law which the department must follow, and the department was trying to figure out what it had to have in policy in order to comply with the federal law and not face federal investigation or federal penalties for not following the federal law. The former Trump administration also acknowledged that federal law requires certain medical care be provided for such inmates when a healthcare professional deems it medically necessary for serious medical needs, and that a prison cannot refuse to provide that type of medical care for inmates.
Thank you. I'm going to open up for questions here in a minute on the agency amendment itself. But just for clarification, so last month, the reg as proposed allowed for and provided for sexual reassignment surgeries for inmates and hormone replacement therapy for inmates. At that time, another person from the cabinet was testifying, and they stated we're waiting on we're also viewing an Attorney General opinion that should come down any time. Later on, that Attorney General opinion has arrived and it came out, and then just correct me if I'm wrong, but this agency amendment basically complies with the Attorney General opinion, goes along with that, and removes that, and basically says we're not doing this in the agency reg, or in the reg. We're going to change. Yeah.
This our agency amendment complies with the Attorney General's opinion.
Perfect. I'm just clarifying everything. Any questions from Senator Yates? This is just on the agency amendment.
Yes, just on the.
We'll come back to the overall reg.
Yeah, just on the agency amendment, because I was under the state just looking at it. Obviously, this would amend the agency amendment to go back to 2018 before anything had put in place. The amendment that was before us before, I was under the understanding that they simply was a DEC request from the Attorney General for guidance, into which the Attorney General put back an opinion that we're going to come into place. But as far as I know, in my review of it, the prior to going back to 2018, the administration did not make a determination of whether or not there was any kind of sexual changes or anything like in the prisons that has not been done and otherwise wasn't addressed. Is that correct?
I'm sorry. I'm not sure
So
I understand your question.
I think it was just framed that prior to going back to the 2018, that there was actual a policy in place that there were sex changes in the prisons. And my understanding, based on the testimony that was here last time, that was not the case.
Yeah, there's never been a policy for gender reassignment surgery in prisons.
And we're looking, this is for clarification to make sure that we're in compliance with not only like the 8th Amendment, but requirements of law as well. And that's, at this point, we're just going back to 2018 as you guys go and regroup and work with the Attorney General's opinion. Is that correct?
Yes.
Okay, thank you.
So I didn't intend to ask this question, but Senator Yates, through his question, brought it up, and I could be wrong. It was my understanding from prior testimony last month that these things were being allowed through an internal DOC memo, based on an internal DOC memo. Is your testimony that they were not happening? First of all, first question, were they happening? Secondly, was there an internal DOC memo which allowed those to happen?
So I don't want to parse words. No gender affirming surgery has happened, did happen, will happen. So, but inmates have received hormone therapy for years. So there were some, as you all know, things that affect inmates' rights have to be promulgated by reg. Instructions to staff do not. So maybe the instructions to staff may have changed, but whether hormone therapy is provided to our inmates has not changed, and we have never approved or provided a gender assignment surgery.
Okay. Any other questions from any other members at this time? Okay. So right now we're just talking about the agency amendment. Is there a motion for approval of the agency amendment? We have a motion. We have a second. Motion and second. Without objection, it is so ordered. So now we have before us the overall regulation as amended by the staff amendment and the agency amendment. Now, do we have any questions from members on the overall subject matter or the overall amendment? Co-Chair Lewis.
Thank you all for coming today. I have a couple questions. Number one, in the previous meeting in which DLC testified, we had submitted a list of questions to you all. Do you all have a timetable on when we will have those answers back?
Well, the question, I'm prepared to answer some of those questions today that you all had submitted.
There was a series of questions that we had. I can go through them, or if you just want to send those to us at that time.
let's do this. I'll give you a chance to review that, and then I've got a couple questions, and we'll circle back.
Okay.
Just a second. Back to the hormone therapy question. So it's your testimony that has been happening. Who pays for the hormone therapy?
So we have a contract with Diamond Pharmacy, and that is where we receive all of our drugs through that contract. So the Department of Corrections pays for the drugs through the Diamond Pharmacy contract for every for everything we get drugs for.
Gotcha. So the state of Kentucky is basically paying for that.
Yes.
Okay. Now the agency amendment, that regulation, is it your opinion, will that change that policy now, or will that continue?
That will continue because that is for all drugs, for all inmates, for all medical needs.
Okay. And so, in other words, DOC's position will be if an inmate's physician says that's needed, then we will continue that.
Right. When the inmate's physician and these endocrinologists are independent physicians, they are not department employees. Mm-hmm. When they say someone needs hormone treatment for postmenopause or menopause, postpartum depression, low testosterone, any medical need.
Okay.
That's when the department would pay for it. But an independent endocrinologist, as far as hormones go, other drugs, the doctor would have to say this is necessary to treat a medical need.
Yeah, I'm sorry, I misunderstood. When you say hormone therapy, you're talking about the whole gamut of
right.
hormone therapy for various
yes.
things. Gotcha. And then I've got another question that's kind of out of place right here, but we'll circle back to it later. While he's reviewing, any other members have questions on these regulations? Okay, Co-Chair Lewis.
Thank you. So it gets kind of specific. How many inmates have received approval by the department's endocrinologist to receive this hormone affirming treatment?
So as of January 8th, in Department of Corrections facilities, we had 12,842 inmates, and of those, 467 total inmates were receiving hormone therapy.
Okay.
For all medical conditions.
And so when we're talking hormone therapy, I mean, are we talking about, let's say, like hypogonadism, for instance, or are we talking specifically about for the purpose of transitioning? I guess the diagnosis code is what I'm asking for.
All right, so I'm a lawyer. I don't have the diagnosis code handy, but that 467 is all the inmates receiving hormones, whether it's, I'm not familiar with that disease, but whether it's postpartum depression, whether it's menopause, whether it's low testosterone, or whether it's gender dysphoria. Of that number, 67, based on the independent endocrinologist's recommendation that it's a serious medical need, 67 inmates are receiving those hormones for gender dysphoria.
Okay. And if you, again, I know some of these questions are specific, but do you have any type of dollar amounts assigned with this as well, as far as how much taxpayer money we've spent?
The Department of Corrections has tried to look at that, but as I testified before, we pay Diamond Pharmacy for all of the drugs, for all of the things, including all of the drugs for these 467 people receiving hormones.
So not itemized.
Not itemized. Trying to break that down for a cost is incredibly difficult.
Okay. And I've got one other question, and this is actually changing gears. I received an email last week, and I'm in the process of continue this conversation. But in the email, the person claims to be a DOC employee. Is there any policy on the books regarding conversations or I guess, conversations with legislators with DOC employees?
Is there any policy on the...
Yeah, specifically in the email, they said that they were not allowed to speak with us and they would have to notify DOC staff. Again, repeating on an email, So
were you asking them for information? Or
if that is a specific policy.
Well, if the legislature requests information, we do have a process to go through the legislative liaison so we can make sure that we get all that information and get it to you. So if you are requesting information, we would ask that you do that just so we can make sure we are aware and make sure you're getting what you need. But I don't think we would outright prohibit somebody from speaking with our legislature.
Okay, thank you. Senator Yates.
Thank you. And I guess you mentioned the attorney. I got my attorney hat on too, and I always think that we get into a dangerous territory, and I'm looking at other litigation whenever states or even the Department of Corrections would try to make a determination of which medicine they're going to supply to inmates based on their own belief of what's reasonable and necessary. I think it becomes dangerous, and I would think that for non-doctors or people, corrections officers, to take a script that's written by a doctor that says this is reasonable and necessary, and then you decide when or not you're going to apply it. And I know that that's part of your risk management to look at it, and so you, as a practice, if you have a prescription that is done by I guess the ranking that is approved is reasonable and necessary medical treatment, you provide that. Is that correct?
Absolutely. We would not substitute our decision for a doctor that said treatment was reasonably medically necessary.
Any other questions from members? Seeing none, there are no deficiency motions or anything on the table at this time. As this will move to the Committee of Jurisdiction next. Thank you very much for the presentation. We really appreciate it. Please call the next regulation.
Thank you.
Justice and Public Safety Cabinet, Department of State Police, 502 KAR 010 120. This is an emergency regulation.
502 KR 10 120E amends provisions to increase the application fee for obtaining or renewing a hazardous materials endorsement for a commercial driver's license as a result of the Transportation Security Administration, TSA, increasing the security threat assessment fee.
Would you please identify yourself for the record?
Nathan Goins, Justice and Public Safety Cabinet, Office of Legal Services.
Nathan Day, Kentucky State Police.
Angela Parker, Kentucky State Police.
Thank you so much. There are no amendments on this regulation. Any questions from members? I have one question. Any questions from other members? Seeing none. I always ask this question when I see increase in fees. So what are we going from to what would the new fees be?
This is a fee that is collected by the Kentucky State Police on behalf of the Transportation Security Administration. The Transportation Security Administration increased their portion of the application fee from $34 to $57.25. So the increase was $23.25.
I think we may be able to live with that. A few years ago, I know we had like the overweight fees and everything like were increasing dramatically. So I just want to make sure that there wasn't anything crazy happening there. So any other questions from members? Seeing none, please call next regulation. Thank you.
Staying with Justice and Public Safety Cabinet, the Department of Criminal Justice Training, 503 KAR 003 140. This regulation has a staff suggested amendment.
503 KR 3140 establishes conduct requirements, procedures for disciplinary action, and penalties for violations of conduct requirements of trainees attending the Public Safety Dispatch Academy administered by the Department of Criminal Justice Training, and material incorporated by reference to be used by agencies regarding the recruits selected to attend the academy. The staff's suggested amendment amends provisions to include the referenced form title, correct references to statutory definitions, correct references to corrected section numbers, and make technical corrections to comply with the drafting and formatting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
Nathan Goins, Justice and Public Safety Cabinet, Office of Legal Services.
Mike Bossy, Commissioner, Department of Criminal Justice Training.
Leah Boggs, General Counsel, Justice and Public Safety Cabinet.
Thank you so much. There is a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second without objection, so ordered. Any questions from members of the committee from this regulation, concerning this regulation from DOCJT? Seeing none, please call the next regulation. Thank you.
Transportation Cabinet, Department of Vehicle Registration, 601 KAR 023050.
601 KR 2350 establishes procedures for review of motor vehicle certificate of title applications, including to authorize the Cabinet to use both human persons and any available technology to review and approve applications, and incorporates material by reference.
Would you please identify yourself for the record?
John Johnson, Office of Legal Services, Assistant General Counsel.
Godwin Arnoldo, Director, Division of Motor Vehicle Licensing.
Thank you so much. There are no amendments. Any questions from members on this set of regulations? Seeing none, please call the next regulation. Thank you.
Thank you.
Education and Labor Cabinet, Department of Education, 704 KAR 003-365. This regulation has a staff suggested amendment.
This regulation is being amended to provide detailed requirements of the content to be included in complaints, determinations, and appeals under the Elementary and Secondary Education Act of 1965. The staff amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Would you please identify yourself for the record?
Robbie Fletcher, Commissioner of Education.
Todd Allen, Deputy Commissioner and General Counsel.
Thank you so much. Welcome, Mr. Commissioner. I think this is your first trip to this committee. Is that true?
Yes, sir.
Yeah. Welcome. There's a staff amendment. Is there a motion for approval of staff amendment? We have a motion and a second. Without objection, so ordered. Any questions from members of the committee on this regulation dealing with complaint procedures? Seeing none, please call the next regulation.
Thank you all.
Department for Employment Services, 787 KAR 001010 and 001370. Both of these regulations have staff suggested amendments.
787 KR 1010 amends provisions to incorporate an additional form by reference that is used for professional employee organizations to create employer reserve accounts with the Unemployment Insurance Fund. 787 KR 1370 establishes procedures for professional employer organizations to file client unemployment insurance wage and premium reports, complete the professional employer organization application for unemployment insurance employer reserve account form, add or delete clients, and change the professional employer organization's contribution election. The staff suggested amendments add a revision date to the material incorporated by reference and make technical corrections to comply with the drafting and formatting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
Buddy Wheatley, Deputy General Counsel of the Education and Labor Cabinet.
Greg Higgins, Executive Director of the Office of Unemployment Insurance.
Anthony Hudgens, Deputy Executive Director for the Office of Unemployment Insurance.
Thank you so much. There are staff amendments. Is there a motion for approval of staff amendments? We have a motion and a second. Without objection, so ordered. I have one question. Do we have any questions from members on this set of regs? Give us an example of a professional employee organization creating an employer reserve account within the unemployment insurance fund, like a basic real life example of that. I think I know, but if you could.
Basically, they are a entity that maintains a group of employers. So before this legislation, professional employer organizations just basically did the administrative tasks such as filing reports, paying quarterly reports, responding to unemployment notices. Now, as a group, they are seen as the actual employer of record, where multiple companies can come into this organization, share common unemployment insurance rates and employees.
Gotcha. So this was, I forget the bill number, but this is in response to.
Yeah.
Gotcha. Any questions from members? Seeing none, please call the next regulation. Thank you.
Department of Workplace Standards, 803 KAR 002-110. This regulation has a staff suggested amendment.
803-2110 amends inspection provisions for employer and employee representatives to clarify that employee representatives may be third-party representatives if there is good cause. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Robin Maples, OSH Standards Specialist with the Department of Workplace Standards.
Good afternoon. Chuck Stribling, Deputy Commissioner, Department of Workplace Standards, and Happy New Year.
Good afternoon. I'm Jason Hernandez, General Counsel for the Department of Workplace Standards Legal Division.
Thank you so much. Happy New Year to you as well. There is a staff amendment. Is there a motion for approval of staff amendment? We have a motion and a second. You guys are doing a great job over there today. Without objection, so ordered. Any questions from members on this set of regulations? Seeing none, please call the next regulation. Thank you.
Public Protection Cabinet, Department of Housing, Buildings, and Construction, 815 KAR 035-060. This regulation has a staff suggested amendment.
815 KR 35-060 amends provisions to convert electrical professions from annual to biennial licensing consistent with House Bill 444 from the 2024 regular session of the General Assembly, convert licensure fees to a biennial basis for consistency, accept qualified military experience as being applicable towards electrical licensure, update existing material incorporated by reference, and incorporate a new form by reference relating to military occupational experience. The staff suggested amendment revises the name of incorporated material consistent with the filed form and makes technical corrections to comply with the drafting and formatting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
Max Fuller, Commissioner, Department of Housing, Buildings, and Construction.
Daryl Morgan, Electrical Division Director for Department of Housing, Buildings, and Construction.
Thank you so much. There is a staff amendment. Is there a motion for approval of staff amendment? We have a motion and a second. Without objection, it is so ordered. Any questions from members on this set of regulations? It is in response to House Bill 444 out of the 2024 regular session, and to comply with that. Any questions from members? Seeing none, please call the next regulation. Thank you.
Cabinet for Health and Family Services, Department for Public Health, 902 KAR 010-120, 122 repealer, 123, 125, and 127. All of these regulations have staff suggested amendments.
902 KR 10120 amends to update definitions, delete requirements relocated to other regulations, add a fee structure for permitting and inspection previously included in another reg, include an annual permit fee, add a late payment fee, add annual inspection fees for public swimming and bathing facilities, assessed according to total square footage of water surface area, including how calculated, a fee for interactive water features, add an annual inspection fee for splash pads and hot tubs, add that bathhouses, restrooms, and drinking fountains shall not be required for design and splash pad construction, include holding tanks under operational water quality standards, change chlorine residual for spas, add testing equipment requirements, add facility enclosures shall not be required for splash pads, exclude animals from splash pads, and update the inspection report. The amended after comments version revises definitions, updates language on the main drain for consistency with federal language, and updates the inspection form to change lifeline to safety line, adds general safety as a category for safety violations. 902 KR 10122 repeals 902 KR 10121 and 190 because the provisions are relocated to other regulations. 902 KR 10123 establishes uniform design standards for public swimming and bathing facilities, including splash pads and spas, including definitions, requirements for plan submission and specifications for approval, fees for plan review, fees for swimming and bathing facility construction inspection, water supply, sewage, and wastewater disposal requirements, facility design, construction, and water treatment system requirements, operational water quality standards, equipment room and telephone requirements, authorization for existing facilities and equipment being used prior to the effective date of the regulation to continue use if meeting certain conditions, clarification the regulation does not relieve compliance from any other state or local laws, and variances for construction requirements. The amended after comments version clarifies when an engineer or architect seal is required on plan submission, allows for equipment to meet either the NSF or American National Standards Institute standards, and adds that inlet piping system not have a reduction in loop pipe sizing. 902 KR 10125 establishes the safety requirements for public swimming and bathing facilities to comply with House Bill 109 from the 2024 regular session, including definitions, lifeguard, emergency telephone, reporting and safety equipment requirements, authorization for existing facilities and equipment being used prior to the effective date of the regulation to continue use if meeting certain conditions, requirements for variances, and updates of form. The amended after comments version clarifies requirements for pools and updates language regarding telephone location. 902 KR 10127 establishes uniform standards for Kentucky public swimming and bathing beaches, definitions, requirements for plan submission and specifications for approval, fees for plan review, fees for public beach construction inspection, annual permit fees, annual inspection fees assessed according to linear footage of beachfront, a late payment fee, water quality, water supply, sewage, wastewater, and disposal requirements, facility design and construction and maintenance requirements, requirements for personnel and safety equipment, water sampling and testing requirements, conditions requiring facility closure and enforcement, authorization for existing facilities and equipment to be used if they meet certain conditions prior to the effective date of the regulation, variances for construction requirements, and the inspection report previously incorporated by reference in another regulation. The amended after comments version prohibits utilizing a municipal sewage system, including a sewage system overflow reservoir, as a public swimming or bathing beach or watershed. The staff amendments for 902 KR 10120, 122, 123, 125, and 127 all make changes to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Julie Brooks, Regulations Coordinator for the Department for Public Health.
Jennifer Burt, Public Safety Branch Manager.
Erica Brakefield, Environmental Management Branch Manager.
Thank you so much. It appears you all have been busy. There are staff amendments. Is there a motion for approval of staff amendments? We have a motion and a second. Without objection, so ordered. Any questions? I got one question. Any questions from members on this set of regulations? First of all, just a comment. I'm really, really happy to see that we will not be using municipal sewage systems and sewage system overflow reservoirs as public swimming or bathing beaches. That's seems like a good idea to me.
We thought so too.
My question goes to the fees.
Mm-hmm.
So when it talks about 165 for hot tubs, these are public hot tubs, right?
Yes.
So when you go to, I'm assuming this applies to hotels. Mm-hmm. So when you go to inspect a hotel and you've got a pool and a hot tub, do you do like 110 for the pool and 165 for the hot tub? Is that?
That's correct.
That's how that's going to work? Okay. What were we doing before?
It was the same process before. It's just all of the fees were in a separate regulation. And because we took the opportunity to separate out that one large regulation into more topic specific, we took the opportunity to repeal the separate fee regulation and put those applicable fees in the same subject matter.
Thank you so much. Any questions from anyone else? Seeing none, please call the next regulation. Thank you.
Thank you.
Continuing with the Department for Public Health, this is the trauma system, 902 KAR 028010, 028020. 028030, and 028040. Out of these, 028030 has an agency amendment.
902 KR 28010 amends to update definitions and citations and make changes to comply with KRS Chapter 13A. 902 KR 2820 amends to update citations and forms, clarify provisions, and add language for a provisional designation. 902 KR 2830 amends to require Level 4 trauma centers to adopt the Pediatric Readiness in the Emergency Department Policy Guidelines, revise job descriptions for the Trauma Center Medical Director and Coordinator, extend the timeline for a hospital to correct identified deficiencies from 6 to 8 months, revise the number of site visitors for the verification team, and update material incorporated by reference. The agency amendment amends Section 11B4 to establish that the medical director's participation in a rural trauma team development course is mandatory rather than permissive. 902 KR 2840 amends to update requirements for the trauma registry and the Kentucky Trauma Data Bank and require trauma registries for all designated trauma care centers to comply with the National Trauma Data Standard Data Dictionary.
Would you please identify yourself for the record?
Julie Brooks, Regulations Coordinator for the Department for Public Health.
My name is Richard Bartlett. I'm with the Kentucky Hospital Association. I'm in the Kentucky State Trauma Program Director.
Thank you so much. There is an agency amendment. Are there any questions or discussions on the agency amendment? Seeing none, is there a motion for approval of the agency amendment? We have a motion and a second without objection, so ordered. So we have before us the trauma system regulations as amended by agency amendment. Any questions from members? Seeing none, please call the next regulation. Oh, I'm sorry. Representative Frazier Gordon.
Hi. I just had a question about the extending the length of time for hospitals to address deficiencies, and I'm just wondering why that's needed or what the process was there.
Well, if you look at, we go through a verification process. We do, the Trauma Advisory Committee does the level 4s, and the American College of Surgeons Committee on Trauma does levels 1, 2, and 3. So it'll depend upon what it is. It may involve something as simple as a staff member who needs to take additional training and getting access to that particular training. The reason we went back and forth a little bit on the rural trauma team development course is that for a while we weren't offering a lot of those, and I found it difficult to require something that I wasn't offering within my own state. I even had to send one medical director out of state in order to get that particular training. We've increased the availability of that in some of the other trainings, but it just depends upon what it is that the deficiency notes. It's just a matter of how much time would it take for them to find a program or to correct a particular problem. So what we'll do is we may give them a designation status for a shorter period of time, and then we'll either re-verify that or we'll have somebody come in and document that change has been made in order to improve the process. And then we'll give them the remainder of their 3-year time period.
Thank you very much.
Any other questions? Seeing none, please call the next regulation. Thank you.
Okay, 902 KARO 95041, repealer.
902 KAR 95041 repeals 902 KAR the Radon Contractor Registration Program because administrative oversight of the program has been moved to the Kentucky Board of Radon Safety.
There are no amendments. Any questions from members on this regulation? Seems pretty straightforward. I'm sorry, you all need to identify yourselves for the record.
Julie Brooks, Regulations Coordinator.
Erica Brakefield, Environmental Management Branch Manager.
Thank you. Any questions from members? Seeing none, please call the next regulation. Thank you.
Thank you.
Switching to Department for Medicaid Services, 907 KAR 001028.
This regulation is being amended to comply with KAR Title 907 and remove references to CPT codes and CPT ranges to reflect the updated capacity of the Department's information technology systems to better assess provider eligibility to provide a service.
Would you please identify yourself for the record?
Good afternoon, Jonathan Scott, DMS Right Coordinator.
Thank you so much. There are no amendments. Any questions from members? Seeing none, please call the next regulation. Thank you.
Cabinet for Health and Family Services, Office of Aging Services, 910 KAR 001210 and 001241 repealer.
910 KAR 1210 is being amended to update definitions and citations, require the state long-term care ombudsman to establish agreements and working relationships with the licensure and certification agencies, require verification that individuals being considered for hire meet eligibility requirements, require advisory council members to have background checks completed, increase the minimum training hours for certification of ombudsman from 24 to 36 hours and specify required training topics, specify annual training hours for certified ombudsman as well as for volunteers who are not certified, and extend the certification period from 2 to 4 years. 910 KAR 1241 repeals 910 KAR 1240, the certification of assisted living communities, because statutory changes have reclassified these facilities as licensed long-term care facilities.
Would you please identify yourself for the record?
Hi, I'm Phyllis Sosa. I'm the Assistant Director of Quality Living with the Department for Aging and Independent Living.
Thank you so much. There are no amendments. Are there any questions from members on these regulations? Seeing none. Thank you so much.
Thank you.
That concludes our regulations for today. Next up on our docket right now is our meeting dates for next time. We have request for Monday, February 10th at 1 p.m. Does anyone know of a potential conflict at this time? Seeing no conflicts, we will now set February 10th at 1 p.m. for our next meeting. Any other questions or comments?